So how do we go about getting our deposit back from an apartment where we were given 72 hours to vacate? That's a good question, because a lot of these apartments, people keep them in good shape and then the storm wrecks them and your deposit's gone. How does that work? How do you get that back?
It all goes back to the, did you terminate the lease because of the hurricane? If you terminated the lease because of the hurricane under Florida law, you're entitled to get back your security deposit as well as any advanced paid rents.
Well, the 72 hours kind of makes it sound like she was evicted. So how does that?
Well, but again, the 72-hour notice, that's kind of that's the first step in a very long list of steps for the eviction process. The first step is to give the tenant notice that they're going to be evicted. That doesn't mean you're evicted. It doesn't mean that you have to leave. It just means that the landlord is saying, look, I'm about to start the process to get you out of this apartment. And you as the tenant, you can either say, okay, I agree, it's not habitable, and you can leave, and you'll get your security deposit and your advanced rents that have been paid back. If you say, no, I'm not going anywhere, landlord's got to go through that eviction process. So a 3-day notice doesn't matter. A 7-day notice doesn't matter. A 20-day notice doesn't matter. I don't care how many notices they give you or what sort of legal language they throw at you or what sort of threats they make to you. Unless they go through that process, you don't have to leave. It's as simple as that.
Now you're laughing at me. I don't know if you wanted to touch on that one yet.
It's just, until a court case is filed, you're not evicted. End of discussion. They can send in, like Les said, as many notices as they want to. And even if it were, just say, not a storm-related eviction, if you want to keep someone's security deposit, there's steps as a landlord that you have to take, and there's timing requirements and disclosure requirements that you have to do to justify why you're keeping that security deposit. So it's pretty difficult to keep those unless you follow those steps as a landlord, and especially in a situation like this where it's an act of God and now you have a structure that's no longer habitable. It's going to be difficult to try to keep a security deposit under any circumstances. So absolutely, they should be getting those back.
So she'll be getting it back. What's her next step in trying to get that back?
Well, she needs to write the landlord, demand the deposit back, and if that doesn't happen, then she's going to have to seek legal recourse in order to get it back.
And when you give notice to the landlord, you're going to want to make sure that you give them your contact information, wherever you're staying, a good mailing address specifically, because if they're going to be returning that security deposit, or if they're going to keep it for whatever reason, they've got to give you an explanation in writing within a period of time. But you got to give them a place to send the letter to.
And it's important.
And it's got to be sent certified mail too.
It's important to do all of this in writing because you need documentation to confirm what was done. A lot of people like to just call on the phone, so we have a record of the phone call. Well, we don't know what was said in that phone call. So it's important to do everything in writing, and if you can do certified mailings, that's the best. But at a minimum, email or text, something that will document what was done and what was contacted, and who was contacted.